Hello, everyone. This is Brian Jackson with Lod Up. We have another good episode for you today. This is a very important aspect that can apply to all of us across the board, and that's the Fourth Amendment. So we're going to go over through the Fourth Amendment. There's a lot to cover, so I don't know how much we'll be able to cover in this episode because there's big chunks about the Fourth Amendment and how it applies to all of us. So we'll start out and by just reading the statute here, the Constitution. So this is what the Constitution actually says. It says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be served. So there's a lot to break down there. And also with the Fourth Amendment, as technology continues to increase and improve, different curveballs continue to be thrown at Supreme Court justices and how it relates to certain technology. Like when the Fourth Amendment first came out, we didn't have cars, we didn't have airplanes, we didn't have computers, we didn't have cell phones. So there's a lot of things that just didn't exist that judges have to figure out how it applies in all circumstances. And so the big thing is cars, and because of the invention of cars, judges have had to try to figure out how that works and what is required for and with the search of a car, and it's usually a little bit lower standard as well as it relates to cars too, and also. The Fourth Amendment relates to not just the search of your home, but it relates to arrests as well. And there's some circumstances where an arrest warrant isn't needed and a police officer can arrest a person in their presence. But if not, then you need an arrest warrant too. So it's just not a warrant to search for stuff, but it's also a warrant to arrest people. And then also, there's a big Supreme Court case that came out, Mapp versus Ohio and Katz, and that relates to searching individuals and stopping individuals and detaining individuals, and also the definition of an arrest. And what an arrest is, and when does a just briefly stopping someone and questioning them come to the point where they're being detained so long that actually constitutes an arrest. So just putting someone in handcuffs doesn't necessarily mean isn't the only way to arrest people. There's a lot of factors and timing to look at on whether or not a person is to be arrested. So let's first kind of just point at the main thing as it relates to the house and searches of houses. And there's definitely a very, very high standard specifically as it relates to coming to someone's house and arresting them and or searching stuff. And the Fourth Amendment is such a good thing. And the framers did a very good job at understanding how humans work and abuse of power and putting a check on the abuse of power. And this is a huge thing, very important, this Fourth Amendment. And I mentioned in another podcast on how it's kind of ironic sometimes with politics where Republicans and Democrats are somewhat hypocritical, and I try not to take a political stance on anything in these podcasts, and I'm fine taking blasts at both sides when it comes to politics. But yeah, so the funny thing is, Republicans are usually, we want smaller government. We don't want as much government involved in our lives. And Democrats are usually, we want bigger government involvement in our lives to help people. Well, those are kind of the main ideologies. But when it comes to the Fourth Amendment, it's completely flip flopped. And usually, when you see conservative judges that rule in favor of search warrants and police officers, because usually Republicans are tough on crime and focus on the police force and want a big and properly funded police force, whereas Democrats focus more on the individuals and too much government overreach here. So that's what I find ironic. So usually in Supreme Court decisions, you find conservatives writing opinions for the state and the police and their actions, and you usually have liberal justices writing against it. And these a lot of times can end up being cases that come down political lines, and because we've had a liberal court for so long, since about the 50s, that that a lot of the decisions on the Fourth Amendment have been more liberal. So in time, that might take a different turn as we now have a conservative court, and it'd be interesting to see how decisions start to play out there as it relates to the Fourth Amendment. And these are cases come up on the Supreme Court's desk all the time. These are one of the bigger high volume cases that come up on the Supreme Court, because the Fourth Amendment through the 14th Amendment applies to all states. And so if somebody has an issue with the Fourth Amendment in their state, they can take it all the way up to the U.S. Supreme Court. If they don't like what the state Supreme Court says on that, they can go straight to, after that, they can appeal to the United States Supreme Court if they pick it up. So a lot happens, and the law changes, can change a lot compared to other areas of the law because of how many issues come up. And again, like I say, advances in technology. So specifically on the home, it notes, the Fourth Amendment, that you have to have a warrant. And so let's talk a little bit about a warrant. And here it says that you need probable cause supported by oath or affirmation. So you need usually what happens is you have an officer and they send a warrant to a judge, and the rules are too that it has to be a neutral and detached magistrate. It has to be someone that doesn't have a fight in the matter. And they send an affidavit and say that based off this, and this, we believe that there is evidence of a crime if they want to search a home. So we believe there may be drugs in the home, or if some counterfeit money, contraband, whatever it is. They identify it and they say why they believe there is drugs in the home. So it typically has to be from some tipster. Like if somebody says, I went into that house and I saw drugs, then that's really good evidence that it's more than likely than not that you can find evidence of a crime. And that's probable cause. That's what the standard of probable cause is. It has to be more likely than not that there will be evidence. And so other evidence can be from tipsters, or sometimes police do stakeouts. And so if they, based off observing the house, they see some kind of illegal activity going on, or somehow they observe drugs, they can submit an affidavit. And this is important too, because you're talking about the Fourth Amendment, and now I'm talking about police observing your house. So where is the fine line? And that's one thing that the Supreme Court has had to figure out too. And the rule pretty much is this: they say the penumbra of the house, and so that pretty much means anything attached to the house. So if you have a detached garage, that's a little bit more hazy, but that could technically be considered the penumbra, but could depend on how far away the house is. But a garage in itself being closed could have Fourth Amendment protections. So the farther away you get from the house, whether it be 1-step, 2-step, 3-step, 4-step, your Fourth Amendment rights begin to weaken. And there could be a lot of factors that play in it. It could depend on whether or not you have a fence and a gate, and whether or not that fence and gate is locked. So you could have greater Fourth Amendment rights for someone who has a gate and a fence compared to someone who may not have a gate and a fence, and you can walk right up to their front door. And so there's decisions that say that if your garbage can is out on the street, that is pretty much fair game, and government officials can rifle through your garbage because, you're throwing it out and you don't really have a reasonable expectation of privacy with that. It's going to the dump anyway. Government's going to pick it up anyway. But also, the location of the garbage can be important. The closer the garbage can is to the penumbra of the house, the more your garbage can be protected. So, if you don't want the government rifling through your garbage can, then you should probably put your garbage can in your garage. If it's just right next to your garage, that still might not be sufficient to say that that's the penumbra of the house and it's protected. So, so government officials can rifle through those areas, your front yard if you don't have a fence, backyard maybe if you don't have a fence. And the big analysis is whether or not you have a reasonable expectation of privacy there. So that's why the gate is important. If you have a gate and it's locked in a fence, then that's a reasonable expectation of privacy. If you don't have a gate and a fence and the gate's not locked, then you have less of a reasonable expectation of privacy, because it's expected that people, like the Amazon guy and everything, might come up and drop off packages. And that's what the courts look at too, is typically if you have a pathway to go up to your front porch, typically that pathway is not a reasonable expectation of privacy. But again, closer and closer you get to the door and the door itself, you have an expectation of privacy. But also, if you leave your door open and the government can peek into that door, then that would not require a warrant, because it could be argued that you didn't have a reasonable expectation of privacy because your door was open, and that anyone could have looked in to your house and seen what was inside. So those are kind of the things that the government can skirt around your home without a warrant with. Then you go more into the house. And so a big case that came out, Texas v. Lawrence, I believe the case was called, where the government officials used a thermal imaging device. So they didn't go inside the house, but they could see with the thermal imaging device, it could see through the walls, and then it could see where warm bodies were, and see if people were in the house, and also see what they were technically doing with that thermal imaging device. So, like I say, new technology, courts always have to grapple with that. And with that case, the court determined that that was too much. And in order to use a thermal imaging device, you need a warrant. That can't be a warrantless search, even though the police officers aren't physically in the penumbra of the home, inside the home, having something that can detect what's inside the home can be considered a search. Same thing, there was a case that I recall that was decided quite a couple years back where the court was grappling with a dog that was trained in narcotics. And if a dog could walk right up to the door of the home and sniff and alert for drugs. And so that's something that the courts had to grapple with too. And it was it's kind of a new technology per se, but not, because we've had dogs forever, but also we've learned how to specially train dogs in finding narcotics. And how the Supreme Court ruled there is they said that, most lay dogs can't do that. And so it's kind of like a thermal imaging device. If you're training a dog to specifically hunt out narcotics, and they have this sense of smell that's greater than humans, and you're training them to say, yes, this is narcotics, this is not narcotics, then that is considered a search. And so you need a search warrant for that as well. So a police officer just can't walk up right to the door and conduct a sniff. There needs to be a search warrant for that. If a dog, so then the question is, well, then, like, how close can a dog get? If you have a dog that can smell hundreds of feet away somehow for narcotics, and it can sniff it from the street, it's a good question, and I don't know if the courts have really grappled with that, but it could be the same thing as a thermal imaging device. Could be like, even though you're farther away and you're not right up the door, you still have this device, and even like a thermal imaging device, even though you're not close, considered a search. And then also, when it comes to a search warrant, you have to specifically describe what you plan to search and what you're looking for. It just can't be a fishing expedition per se. So you just can't say, I think there's crime committed here, and then you can turn the entire house over. So like what the Fourth Amendment specifically says is particularly describing the place to be searched and the persons or things to be searched. So it has to be a little more specific on, we think there's drugs in these homes at these locations. Obviously, police officers, it doesn't have to be too specific, and police officers don't know the layout of the house based off tips. But there can also be issues if police officers go beyond the breadth and scope of the search warrant. And maybe the search warrant is too broad, that just says search the house, instead of you're searching the house for these papers or this disk drive. And you're searching areas of the house where there may not be those types of things, and you turn it upside down. And again, people still have a reasonable expectation of privacy to some areas of their house where there's not probable cause. So if it's specifically like, we think that they're making drugs in the basement, and they go around and search other areas of the home outside the basement, maybe there might be argument to say that, yes, there could be some more stuff connected, but also there could be some circumstances where it's like, well, what are you doing here? Why are you going into that room? So also it's important for officers to make sure that they at least have some parameters, and it's not too broad, or a search warrant can be struck down for being too broad. And so let's talk a little bit about what the remedies are for a Fourth Amendment violation then. mean, some people may think that, oh, Fourth Amendment violation, my case gets thrown out. And that's not necessarily the case. It can and it can't be. And what the remedy is, the real remedy is if the police take evidence from your home, and the only way that they can prove their case is from the evidence that they found from the search warrant. And it's found that the search warrant wasn't supported by probable cause or some other issue with the warrant, or they didn't get a warrant, period. Then the remedy is suppression of evidence, meaning that that evidence can't be brought in at trial. So what attorneys do is they can file a motion to suppress evidence based off Fourth Amendment violation. And if the only way the state can prove the case is through that evidence, that's the smoking gun, they don't have any other smoking guns, then their case can be dismissed. But if there's other evidence they have, then your case won't be dismissed. It may be harder for them to prove the case because they're missing some evidence now, and you can't talk about that evidence in trial. And if they do talk about that evidence in trial, that could also lead to a mistrial as well, because there's obviously a judge has ordered you can't talk about this. This evidence has been suppressed, and so if somehow it comes up in testimony, either by accident or by purpose, there could be a mistrial, and there could be there could be an issue on whether or not that could be retried. Possibly it could, possibly it couldn't. So that's the remedy for a Fourth Amendment violation, and that's usually how it works for the Fourth Amendment and homes. And then when you go outside the home, you have less of a reasonable expectation of privacy. You're not in your castle anymore. You're not in your bunker. You're out in the open. You're out in the public. And so if you're out walking in public, then there's a lot of stuff that's way more fair game. Taking video of you, watching you, seeing where you are. Government can watch you and your movements around under the Fourth Amendment, because again, the theory is, if you're somewhere where somebody else might be able to be, then you have less of a expectation of privacy. But still, you do have an expectation of privacy to things that you may have on your person. So if I have a backpack and I'm walking around with my backpack and or my phone, I have my phone on me, or other things that may have a closed container, a purse with a zipper on it, stuff like that, or just, if I have a box, a package that's taped up, I can still have a reasonable expectation to those things as well. And so in order for a police officer to open and search my backpack and containers, they need evidence that that there is contraband in there. If they don't have evidence at that time that I have committed a crime, and they have nothing on me, and they're just searching because they have a hunch, they're concerned, whatever, but there's no probable cause that I've committed a crime at that time, and or if I've committed a crime but nothing can be related to that type of crime that I've committed, then they can't search those things and places. So, but also there's if I get arrested, then it's a closer call, and then the question is, can they search those things? And it's can be hazy. Some may say no, some may say yes. And it's called a search incident to arrest. So if I get arrested on site, the search incident to arrest exception is is to make sure that police officers feel protected and they're searching for knives or guns, or any weapon to make sure that they won't be harmed and people around them won't be harmed. So that's kind of and obviously officers take advantage of that, and search everywhere, where they may not find, or they may not feel like they're safe, especially when when the individual already has handcuffs. But there could be, so it could be a case by case basis, and it could depend on the type of person and who they are, and kind of their background. And if you're going after someone who really is a danger to society, as far as someone committing assault or murder, there could be more of a basis to check their backpack, if there's something fishy in there. But the arrest is more related to, like, if it's a civil infraction, if somebody gets a citation or something of a smaller like crime, and then they search the purse, maybe you could say that, hey, I had a reasonable expectation of privacy, couldn't open my purse at that time. But usually it can go towards the police officers at that time. And then also that relates to cars too. Search incident to arrest, if I get pulled over for speeding and I'm going 40 miles over the speed limit and they're arresting me, then the question is, where can police officers search in a search incident to arrest? And usually you see that scenario in a law exam question, and because that's how it's easy to for law students to kind of get tripped up there. And usually, if the trunk there's probably a reasonable expectation of privacy in the trunk, and definitely if you have a backpack or containers in the trunk, if they go and search incident to arrest, there could be a violation there. There's also another exception to, if police impound your car, they have to take inventory of everything. And so if they're taking inventory of your car to make sure that everything's there, to make sure that nothing's missing, and for their purposes and record keeping purposes, then there could be an exception there too, that they were able to search your trunk and or your glove box for inventory. But typically, if you've been pulled over for speeding, probably your glove box and your trunk and your backpack are safe and require a warrant, and they have to prove that there's evidence of a crime. And again, like speeding, you can't prove that there's more evidence of the crime of speeding in a backpack, because the evidence of the crime is the guy's foot. Essentially, there's nothing else can really be related to this guy speeding. So in that scenario, searching backpacks, searching glove boxes, searching trunks could be considered that was beyond the scope of a search incident to arrest. And so now we kind of get to the Terry stop, and what this relates to is an officer's right to stop someone and say, hey man, what's going on? What do you got? What are you packing? And this one is a hazy one and arbitrary, but it is where we are in the law. But it allows officers to briefly stop people and detain them just real fast. If and it's a lower standard than probable cause. It's a reasonable suspicion. So if you have a reasonable suspicion that criminal activity may be afoot, if you're an officer, you can briefly stop someone and determine whether or not there's crime. But reasonable suspicion there has to be something articulate. You just can't say, oh, that guy looks shady. That guy was wearing a hoodie. That guy was a certain race. That guy just, he looked homeless or whatever. It has to be a specific reason, like I saw I saw what looked to be a gun in this guy's pocket. I saw what looked to be drug paraphernalia in his mouth, or maybe there could be a scenario where there was a bank robbery and this guy's running, or something similar. He's running from a scenario where officers knew there was an incident occurred, so that could be enough for reasonable suspicion to stop someone. And so when you stop someone, then you can also quickly frisk them again for, you can pat them down quickly to make sure that you're protected again. So that's Terry frisk, where again, officers are looking out for their safety when they're reaching out to people, so they can just quickly stop, quickly frisk to make sure they're safe, and then can question them a little bit. And then at that point, when they question them and there's nothing, there's no evidence of a crime at that point. I mean, if they do find evidence of a crime, then at that point could potentially have enough for probable cause, and they wouldn't need a warrant at that point if they're carrying narcotics or something. They know they're committing a crime at that time. But if there's no evidence of a crime, then they have to let them go at that point and can't detain them further. And if they detain them further, then that could run into an arrest situation. Even though they may not have handcuffs on them, it can still be an arrest. And it's kind of a standard on the length of the stop, and it's, there's no clear-cut criteria on what's too long, what's too short. But I mean, obviously, if you stop that person, you ask them questions, and they've already given you the answers, and there's no evidence. At that point, if you keep detaining that person, then you're getting into an arrest scenario where you need a warrant. And and so the question is from a standpoint of the person that's detained, you ask, did that person feel like they were free to leave at any time? And there's a lot of scenarios where it's in a public place, in a park, and obviously the state always argues that, oh yeah, he was in a public place, he could leave at any time. But I mean, it's not that simple. And obviously you're dealing with an officer that has a gun, and if you run away from them, an officer can charge you for an additional crime, for criminal mischief, or fleeing an officer, or whatever. And so state always argues that, hey, it was just not an officer, he was in a park, he could have left at any time. But that's not necessarily the case. And I think I would say that it usually, if you're being stopped by an officer and you're being held for a long time, I would presume that most people would feel like they weren't free to leave, unless there was express language from the officer saying that, hey, you're free to leave, or just maybe on the circumstance and how the conversation's going. But usually, I think most people would feel like they weren't free to leave. But again, it's case-by-case basis. And if not, then again, they get detained. Then it's an unlawful arrest. and and so when it comes to pulling over people in a car too, a officer has to have probable cause as well that there has been criminal activity. So a police officer, I think I remember in middle school, one of my teachers who had a sibling who was a lawyer, they were pulled over and the officer just said, hey, we're just randomly pulling over people and just doing a quick check, just make sure everything's okay. And his attorney brother was like, hey, you can't do that. You need to let us go. And then the officer said, hey, you're free to go. And yeah, so stuff like that can't happen. The officers have to have a reason to pull you over, but there could be a lot of reasons. I mean, if your registration is expired, maybe if your windows are too tinted, maybe if your license plate is covered or tinted and not very viewable, if you're speeding, if there's some concern about the safety of the vehicle and how it's operating, could potentially, because that could potentially be a traffic citation and not following whatever law your state has to as far as the safety feature of your vehicle. So an easy one is obviously if your headlight is out, they could pull you over for that. And then with DUIs, usually you need, again, evidence. Like if they're pulling you over because they think you're under the influence, then there has to be evidence from your driving that you're under the influence. And typically the law allows you to go over the lane one time, two maybe, but could be pushing it. And again, depends on the circumstances. But if you're swerving around left and right, then that's enough probable cause to say that, hey, this person might be under the influence. But this is probable cause to stop you. And that's why, but they still need to do a stop. To do a stop, which is like the Terry stop, and then to continue to inquire on whether or not you are intoxicated. They need more evidence after they stop you. So this is where it gets really nitpicky. And again, technology, there's been specific opinions about this. So, and officers have been trained very well to put in their police report what they saw. Like, for example, they always say, well, I saw that his eyes were bloodshot and that his speech was slurred. And or I saw, I smelled alcohol emanating from his breath, or I smelled alcohol emanating or marijuana emanating from the car, the strong odor of alcohol emanating. And they're usually trained really well on the legal terms that need to be done. So there's no issue down the road on questioning whether or not they had probable cause, because if you have that evidence that, hey, this person is under the influence, then you can technically arrest/detain them, and do further inquiry. And then that's where all the crazy hop, skip, and jump stuff come in. And so usually what they do is they take an object and they make you follow your finger, and that's called the nystagmus test. And they see what they're looking for: smooth tracking. They're supposed to do a certain amount of passes, and see whether or not your eyes are smoothly tracking or not. And then also they can do the walk test, where they make you walk in a straight line. and see how well you walk in a straight line. And they can do some other similar tests. Those are the main ones: walking in the straight line and the stagma test. And usually that's where it gets nitpicky too, and where DUI attorneys really hone in on, because that is determining whether or not you have probable cause to arrest them. And so if they don't do a test correctly, that could be enough evidence to say, hey, you did not do this test correctly, to say that this person impaired, you didn't follow standard protocol, you didn't use this proper, you used your finger instead of a pen, or you didn't hold it from this far away, or you didn't let them take this many steps, or something else to say that, hey, you didn't have actual probable cause to arrest this person. And then also breathalyzer tests, so that's a big one too, and blood tests. And so they can also use a breathalyzer to see if you're to see what alcohol level you're at, and then also they can take a blood test. And the Supreme Court has come out and said, and this is an interesting one in my mind, that you don't have a reasonable expectation of privacy to your blood. And that one I think is a little weird. But so essentially it means that the government can take your blood without an arrest warrant. And also it's tied, but I mean, technically you can refuse to, but I mean, you can refuse. So there's the breathalyzer test. And so technically you can refuse the breathalyzer test at the scene, but then they can take your blood later. But if you refuse the breathalyzer, that could be a whammy against you for your license, because license to drive isn't necessarily related to a right. It's a privilege, is what they say. And so if you refuse a blood test, they could use that as a basis to suspend your license, just the fact that you refused. So that's an issue too when it comes to DUI. So there's a lot of stuff when it comes to cars that get litigated in stops, and then also all the crazy DUI stuff. There's a lot of stuff there, and it's definitely a very specialized area of law, DUI laws, because there's so many hoops the police officer has to jump through to determine whether or not you're intoxicated, because it's not just the fact that you're under the influence of alcohol. You have to prove that they're over the limit of alcohol to the point where they're impaired based off whatever state intoxication level they have. Some states have lower ones, some states have higher ones. But yeah, that's pretty much how it works with the Fourth Amendment with cars. Also, when we're talking about new technology and everything, there was a famous case, Kylo 2, from the Supreme Court, where they put a tracking device on a car, police officers, and were able to track the movements of the car. And, we talked about the home and the penumbra and how you have higher rights when you're in your home, and it goes down and when you're out in public. But the courts decided that was too much too, that putting a tracking device so they can know every location where you are was too much, and you can't do that either. And then also for your phone, if you have a lock on your phone, then you could say that you have a reasonable expectation of privacy to your phone, and you probably need a warrant as well to get into your phone to search that. And so, yeah, typically I'd say that police officers need a warrant unless they have evidence that some crime has been committed, but I think that would be really hard. So I think typically to search a phone, they need a warrant to search your phone as well. So that's kind of a 500-foot view of the Fourth Amendment and how it works as it relates to arrests and warrants in the home and driving and the Terry stop. And there's definitely a lot more in there too that we haven't covered as well. There's definitely exceptions to the warrant rule. We didn't go a lot into, like, for example, if there's like an ongoing crime or you're chasing an individual and you go into their home because of a crime, then that could be an exception, as well as other exceptions. Yeah, there are some nuanced parts where the government can kind of skirt around not getting a warrant and or kind of skirting around the suppression of evidence. Because even if evidence is suppressed and they got it one way, they can make an argument that, hey, well, we could have got it this way, and that could have been legal, and so that evidence should still come in. So even if you get a suppression of evidence, the evidence still might come in if they can prove that there was another legal way without a warrant that they could have got that evidence to. So that's it in total. Fourth Amendment. Like and subscribe to learn more about the law, how it works, and we'll talk to you next time.